Okay, so we're going to go ahead and get started with our final panel of the day. One quick note, right after the panel, we're going to hear from Elizabeth Kirk, who's going to talk about the e-journal focus on ecosystem services. There's already been a call for papers put out, so she'll tell us a little bit about that. And Louisa's going to talk a little bit about taking some of the information from this workshop and bringing it to the IUCN World Conservation Congress in September in Jeju, Korea. And then we'll talk about our plans for developing a book to be published with, hopefully, Edgar Elgar. So we'll let you know what next steps are at the end. But first, we have a panel on case studies coming from the European Union. And our first speaker is Leonie Rines, sorry. That was not as smooth as it could have been. Leonie is going to talk to us about environmental protection versus energy supply security. She's going to be focusing on shale gas, which is a very important and aggressively advancing topic. So, Leonie.
Good afternoon, thank you. I'm Leonie Rines, a PhD student from the Catholic University of Leuven in Belgium, and I'm going to talk about, as Melissa already said, the shale gas case and its impacts on ecosystem services, and it actually connects pretty much to where David Honders left us right after the break, so yeah, enjoy. In the paper, I will establish how an ecosystem service approach to regulation of shale gas could look like in practice by comparing the US and EU regime, which is how it is existing today. But first of all, I would like to give you a brief introduction of what shale gas and hydraulic fracking is. Shale gas is a natural gas which is primarily composed of methane, and it is trapped in fine-grained rock formations. The main challenge, and different to other conventional gas resources, is that it has a very low permeability, meaning that the released hydrocarbons flow slower than usual. However, through the advantages in the hydraulic fracturing technique, this process is speed up. The hydraulic fracturing or fracking was introduced 2005 in the US and is now a more advancing technology also used in the European Union. As you can see on the picture, through the fracking method, fracking fluids are introduced into the rock, really deep into the shale formations, and it creates fractures and cracks. The fracking fluids are also composed of sand, which creates those fractures open so that the gas is released and it can flow through the pipe to the top. As you can maybe imagine, this is concerned with a lot of impacts on the environment on different levels of ecosystems. One example is that the seismicity of a rock is changed enormously, and this leads to earthquakes, as already has happened in the UK twice the last year in Blackpool. Also, it has huge impacts on water resources. Several thousand cubic meters of water is used for each well, and when the hydrocarbons comes to the top, a lot of flowback water comes with it, containing highly toxic chemicals, which might result in pollution of the groundwater resources, drinking water resources, and surface water. Besides impacts on air pollution is the methane which is released with the gas, besides truck movements through the enhanced drilling technologies and the use of diesel motors. Also, the wastewaters are sometimes discharged directly into underground wells, these can mitigate, and well, we'll see later what is about that. So these impacts have also impacts on the wildlife, the animal health, and the human health. Nearby people which live in residential areas report that they get sick from suffering health problems such as headaches, and that their drinking water concentration is sometimes 17% higher contaminated with methane than in other wells. I think already from this very brief and simplified description of the shale gas fracking process and environmental impacts, that gives an idea of the vast regulatory regime involved to regulate such an extraction process coherently. Therefore, it is even more surprising that in both jurisdictions, the US and the EU, there is no overall shale gas regime or shale gas act existing. On the contrary, general energy and environmental laws, which are also applicable to conventional gas resources, are applicable here. These are several different pieces of law focusing on different areas. In the US, for example, it is the third law, the NEPA, the Clean Water Act, the Safe Drinking Water Act, and the Clean Air Act. Plus, in practice, a lot of regulation is left to the states, so that these acts might vary as well. In the EU, a set of over 50 directives and regulations apply to shale gas extraction activities, which are all transposed into member state laws. These are, for example, the REACH regulation, the Mining Waste Directive, the Environmental Impact Assessment Directive, and the Water Framework Directive. Plus, there are several member states which have their own laws applying to shale gas. It just can be concluded that all these regulatory systems in both jurisdictions, they do not have pay regard to cross-cutting issues, and they are also drafted to ensure a specific aim, and they do not focus on ecosystem services. Thus, it creates a rather fragmented approach of regulation. Having in mind these vast environmental impacts and the regulatory regime involved, this leads us to the core of the paper and the question of what should the law look like, having regard to the benefit and risk of an ecosystem service approach, how policymakers can design ecosystem service programs, and the implications of ecosystem services and environmental and economic equity in order to establish an ecosystem service approach to shale gas regulation. This leads us to the core of the paper. Three crucial elements have to be addressed in order to establish such an approach. Firstly, one has to consider the right level of regulation, the institutional setup, and the power of the law itself. The right level of regulation, it needs to be established if a local, or in the case of the US, a federal, in the case of the EU, a subnational level is important and the most appropriate level of regulation. As we all know, scholars are in disagreement over the right level of regulation and the right level of valuation and quantification of ecosystem services. The same applies to shale gas. To date, in practice, the laws are rather established on a regional basis, which is in favor for the industry. However, governments and to some extent also local communities would prefer to have a rather federal, or in the case of the EU, a subnational regulation. Advantages and disadvantages can be found on both sides. On the local level, I'm not going further into depth into the valorization and comparability argument, since this has been addressed to quite some extent today. But a local approach would guarantee a more holistic and coherent regulation applying to shale gas. Especially, it involves so many elements of the environment and so many different ecosystem functions and services. Also, a regulation on a local level would be easier to monitor and enforce. And having regard to the fact that most, not all of them, but most of the impacts of shale gas are local in its nature, putting besides the greenhouse gas emissions, it would be more logical to also fight them with a local regime. Also, local mechanisms are more flexible and easier to adapt to the specific drilling sites, conditions and needs. However, a regulation on the larger scale would have regard to the drilling process as it is a very complex issue, since the local authorities might lack the needed experience, competence, as well as the capacity and the overall mandate. Also, having regard to the trans-border issues, as I said, not all impacts are local in its nature. The air pollution, and especially the fact that wastewater is disposed in underground ways, which mitigate across state borders, can cause harm in states which are not directly involved in the extraction process, and therefore don't have any laws and regulations and measures established. Further, a more federal or subnational level would shift the burden of precaution and compliance from the local authorities to the industry, and thus set incentives for further investment therein. Also, which is always important for the European Union, it would prevent a race to the bottom phenomenon. With shale gas, a race to the bottom of the regulation would further enhance the competition of states to attract the oil and gas industry to drill in their own territory, since this would be more economically viable with less strict environmental laws. Following from this, it can be established that an adaptive federalism regime would be the best model of regulation. That means that on a federal or subnational level, same minimum environmental standards would be established for the environment and ecosystem service protection. The components of this regime would be further discussed under the section The Power of Law. And in a second step, this general framework would have to be implemented in the specific states and on a local and state level, having regard to the specific local conditions of each drilling site. Regarding the institutional setup, in both jurisdictions, the implementation, enforcement, administration, and monitoring regimes are spread amongst different agencies, government institutions, and levels. There is no clear setup in either field, neither for ecosystem services or shale gas. In the United States, for example, the state environmental protection agencies are involved, as well as in some states, the river basin commissions, where the individual drilling site is located in. In the European Union, enforcement and monitoring schemes may vary from member state to member state. In the paper itself, I will get a bit deeper into these issues, since that would spread the time frame. However, right now I just want to focus that the river basin commissions would be one possible solution for an institutional setup, since as applicable in the United States, they are multi-jurisdictional bodies which cover a river basin, which is of course cross-state or can consist of several states, and these bodies can enforce binding regulations. According with shale gas, they control the drilling operations and all the water-related issues in the individual states, and so they have they can adjust to the more local needs. And however, on the same time, they they have binding effects. Of course, in order to have regard to all the elements in ecosystem service functions, the mandate would have to be extended to other elements as well, so that they can also regulate an air, for example. The last part is the power of law directly. There are several elements of regulation needed, especially in the areas of property rights, liability, environmental planning and permitting, as well as tax issues are important for shale gas. Regarding property rights, the literature is of the opinion or states that the main reasons for the failure of the implementation and enforcement of an ecosystem service approach in practice is the lack of properly defined property rights. The tragedy of the common leads to market failure and results in lack of incentives for an ecosystem service approach. However, the shale gas example does not totally fit in this general presumption that the lack of property rights leads to the exploitation of ecosystem services and goods. For shale gas, the property rights are most of the time well allocated and well defined. Extraction takes mainly place in private or state-owned land which are leased by extractors. These pay lease or royalty payments to the original landowners. However, the landowners only get payments for the land and the underlying resources. Thus, they have no incentive to protect the ecosystem services associated with the latter, even if they are provided parallel to the energy ecosystem service functions and equally affected by the extractions. These additional ecosystem services and their values are not considered in the property payment schemes. However, the fact that for shale gas extraction activities there are clear property rights defined today is already an advantage. So with the shale gas case, these property rights just have to be adjusted regarding the use and access rights. More precisely, that means that incentives or obligations for the surrounding and supporting ecosystem services have to be included in such a tenure system, so that either the original landowner, preferably the extractor leasing the property, would have to reflect the value of these services in the economic decision-making and is forced to use these ecosystems sustainably. Regarding liability, strict liability, including also tort liability, are not only ways of implementing the polluter pays principle into laws and regulations. Especially strict liability is also said to have a preventive and precautionary effect. Thus, an enhanced liability regime for hydraulic fracking would shift the burden to the industry, away from the local authorities, and set incentives for greater care and precaution regarding the dangerous activities in general. Regarding the environmental impact assessment, in both jurisdictions, an activity has to undergo an environmental impact assessment or environmental impact statement. However, in the European Union, the shale gas activities are exempted from the scope of the environmental liability, the Environmental Impact Assessment Directive. From this it follows that an impact assessment for shale gas resources are not mandatory on an EU level. Thus, the decision if an environmental impact assessment for shale gas activities should be carried out lies within the discretion of the individual member states, and it will be decided by a screening procedure on a case-by-case basis if such an assessment should be carried out. This, of course, leads to the fact that in some member states environmental impact assessment might be carried out, in others not, which is, of course, I don't have to state the impacts of that. I'm not going to repeat what David Hunter said about the US and the NEPA. They have a rather fragmented approach as well. And on top, since a lot of the regulation is left to the states, you would also have to comply with state NEPAs or small NEPAs, which also set different standards and criteria. So in both jurisdictions, this is a rather fragmented approach as well. Regarding the permits applying to shale gas, the companies which are willing to undertake shale gas extraction activities must receive several different permits before the construction of an activity can actually begin. However, especially in the United States, there are a lot of gaps and exemptions applicable for the permitting procedure in shale gas. Usually, activities need a permit under the National Pollution Discharge Elimination System, under the Clean Water Act. However, this permit is only needed in case of direct discharge of wastewaters into surface waters. But since most shale gas facilities store their wastewaters in underground storage wells, they are not required to obtain such a permit. Further, in 2005, the Energy Act excluded the practice of hydraulic fracking from the definition of underground injection in the Safe Drinking Water Act. Thus, the permitting procedure for Class 2 injection wells, which wastewater is normally stored in, are left to the states, so there is no overall permit applicable, leading to a fragmented and coordinated approach as well. The European Union, with its integrated pollution prevention control program, sets for one extent a good example in that it's only one permit needed for the entire activity, so that the burden can shift from one element to another element. Lastly, regarding tax laws, this tax is still, to date, the most popular approach trying to establish an economic equity, ecological and economic equity, and to overcome the problem of free riders. Also, regarding shale gas ecosystem service, one option would be to create ecosystem service districts, which means that you would tax the multiple beneficiaries of an ecosystem service in a given region, and then use the resulting funds to protect the sources of the services. This would ensure that cross-cutting issues and effects are guaranteed and taken into account in a regime, and one way to establish economic and environmental equity. To conclude, it can be stated that an ecosystem service approach ensuring economic and environmental equity is well possible for shale gas. One has to refer to three different important components. First of all, the adaptive federalism regime of regulation. Then the creation of a subnational authority, like, for example, the river basin commissions and districts in the United States and European Union, which are able to issue binding regulations, but this has to be adapted to the extent that all ecosystem services are included in such a measure, not only water services, as today with the river basin commissions. Further, the environmental impact assessments and the permitting process needs to be adopted in both states, as well as with the other components I used earlier. And once this happens in practice, the operators will be able to compare the investments in physical capital and the ones in natural capital, and come to the conclusion that they should use the services more sustainable. Thank you very much. Any questions or comments? Yes? Yeah, you. Okay.
My question is about the possible relationship between shale gas, fracking, and earthquakes. What do you think? And do you think that the precautionary principle will step in sooner or later, or you think that there's no basis for that?
The problem is that earthquakes already happen to some extent in the UK, for example, and there even it was considered that it would relate. It was approved that it would relate to shale gas activities. The facilities were only closed for some extent, I think a month or so, and then they could go on with the fracking process. So unfortunately, I don't think the preventive principle is going to apply here, which of course it should have been. Okay.
Could you elaborate a little bit on the term adaptive federalism and whether you think this actually increases or reduces incoherence?
Yes, I think it would increase the coherence because right now it is either federal regulation or local regulation, but they are not connected with each other. So I think having a general framework, setting minimum standards, and then having local authorities and local people decide how to best implement, and having regard to the specific needs of the individual drilling sites, because the seismicity of the rock is of course not always the same, as well as the extraction surrounding the landscape is not always the same farmlands. It would have to differ on the individual drilling site. So I think with this mutual communication, adjusted with an institutional setup as with the river basins, which are not only focusing on one element and not only applicable to one stand, this would increase the coherence.
So about U.S. property rights and in shale gas, but then also underground resources, I'm actually wondering if you could comment on how an ecosystem framework would apply where there are some cases, Texas, for example, has held that, and actually the common doctrine in the United States is that you only, the rule of capture, which means that, as you know, it means you don't own the resource until you extract it. And the complications with that are that, first of all, it creates a race to the bottom to extract as much as you can, because nobody else can complain unless you're subject to some type of anti-waste law or restriction on extraction that the state has imposed. But the other thing is that the injection back of polluted water, you're technically not polluting anybody else's water, so nobody would necessarily or clearly have standing to challenge the injection until they actually are pumping out polluted water. So that's why you wouldn't have a precautionary approach, because it's hard to establish liability rules for having water polluted underground unless you can show that it's your water that's being polluted underground. And so how would an ecosystem services model address these complications once we dig into U.S. property law and who owns these underground resources?
Well, I'm not an expert in the U.S. property law, I have to say it first, but I think having such an approach and making at least in the European Union, making the landowners aware that they are not only giving away the license to drill, but also the ecosystems related with that, and creating incentives for them or making them aware of the fact that they should conserve them. That would be one possible issue for how to regulate it.
Doesn't it run the risk, though, that, so I'll just say, okay, you can drill, but when you dispose of the waste, I want you to dispose of it on this part of my property. I don't care. I don't need that water. And I mean, it seems like you're creating an even greater risk of the tragedy of the commons, because as the person who is giving you the land access, I'm getting royalties. I don't really care what you do once the royalties are good enough that I don't really care what you're doing environmentally.
Well, I would think that making the people aware of the fact they would, that they could even get more money with it, would make them think about it, no?
Oh, I see. I see what you're saying. Huh. Okay. I'm just curious.
Let's continue that later.
Oh, yeah. Okay. Any other questions? Okay, thank you very much.
Thank you.
So our next and final panelist is Nathalie Fornero, and she is going to be speaking about ecosystem services and sustainable development, creating an integrated governance approach, critical reflections on the new European strategy on biodiversity.
Okay, good afternoon. I just have a question. How it's possible to use this computer? Because it's PDF format. And
It's not working. No, since this is a PDF, I don't know.
There's a keyboard underneath.
yes,
That might be easier for you.
Can you just use those?
Somehow it went off.
okay. I think
Hold
it's
on, it's not even on.
okay.
Yeah, it
With
will.
this mo-
We just need the.
Okay, yeah, okay.
Got it?
Okay, yes, it's okay for me.
Wait, we don't have a screen now behind you.
Somehow this got turned off.
Which one we want to?
Well, we just want
It's
that.
because
Oh,
it's
I'm sorry.
PDF.
Okay, no,
Okay, if I can use.
very good.
Okay, yeah, thank you.
You can use this if you want. Just these
Oh,
buttons.
yeah.
There you go.
Wow, thank you.
There.
Okay, good afternoon. So we have 20 minutes?
Yes.
Yeah? Okay. Everybody is tired as I am, so I try to present my paper in short time, I hope, with my so French accent, in English, of course. So I'm very pleased to be here and to participate to the 10th colloquium of the Academy and to participate also to this workshop organized by EUCM and the Academy. I would like also to thank the organizer for their welcome and to accept my presentation. So my study is a part of a research program which in France several researchers decided to create a network, national network at the National Center of Scientific Research on the topic biodiversity, law and ecosystem services. So I am in charge of this network. In this network, which is created in May this year, we decided to discuss and to share reflection of the introduction of the concept of ecosystem services in law, to discuss about its impact and also its impact of the integration of environmental requirement into different branches of law. As you can see, we have the logo, if we can say that in English, of a new network. We decided to call it Biodyssey because it's a real challenge to discuss and to construct a legal framework on ecosystem services. So the purpose of my study today is to assess the interaction between law, ecosystem services, and sustainable development in the prism of the very ambivalent concept of governance. I decided to concentrate my reflection on the new European strategy on biodiversity. As you can imagine, all those debates, indeed, controversial concept, raise several questions for lawyers. And it's very important to have such workshop and to have different presentation during the colloquium of ecosystem services and the panel of ecosystem services. So I decided to construct my reflection on the following question: how to prevent and regulate a strictly economic approach of ecosystem services. And as we can listen this morning and listen this afternoon, this subject of economic approach of ecosystem services is really a challenge for a lawyer. How to prevent that offset unfair approach at the different level of European policy, and Solange this morning showed us the dilemma of such a question. And also, my third question is how to prevent it and also to sanction the risk of regression of environmental law. In France, we have Michel Prieur, it's a professor of environmental law, which decided to create a group on regression, the principle of regression of environmental law. And I think it's very, very interesting to ask the question, is the new concept introduced in our law could be a risk of regression for the environmental law? So I decided to ask 3 questions to illustrate my reflection of governance. We decide, of course, how to combine EU competencies and member state competencies, how to combine state sovereignty and political authorities. So we have many questions to ask about democracy and governance. How to promoting new model of governance to ensure conservation, valorization, and also restoration of ecosystem services. And the third question is where and which time, the past, the present, the future, and to see the cycle, the evolutive activity of ecosystem services. So before answering all those questions in a short time, I decided to present you in a few minutes the context of my subject and the concept which I use. As you can read, it's not useful to read all this, but it is very important to see the major objective of the EU law and EU strategy on biodiversity. The first objective is really very classic, I will say, because we have the same at the international level. Halting the loss of biodiversity, of course, and the degradation of ecosystem services, of course, in the light of the green economy, of course, and sustainable development. The second objective is very interesting too, because it's a question of restoration of degraded ecosystem and degraded ecosystem services too, and the promotion of green infrastructure. And the green infrastructure is really very linked to the notion of ecological engineering. And it's very interesting in terms of innovation and in terms of technological tool to pursue this objective. The third objective is, of course, supporting economic evaluation of biodiversity and its multiple ecosystem services. But in the communication of EU, linked to the report of TEB, we can see in the discourse that we have to link the economic evaluation to the take into account the intrinsic value, to take into account different value of nature. And the last one, objective of the EU, is how to create a partnership for biodiversity in order to reach all this and all this objective. And in the strategy of EU law adopted last year, we can see that EU law decided to reinforce the participation of many stakeholders, and especially the private sector, linked to the necessity for EU law to evaluate the economic value of ecosystem services. Just a few words about the concept. I think it's very important to think and to discuss about the concept. What ecosystem services, sustainable development. Okay, I think we have all the definition of a Brundtland report, and governance. Why it is important? It is important for a lawyer to have a definition in order to have a qualification and after to have a legal rule and framework. So in EU law, just an explication. I don't know if you use this concept, hybrid concept. We use this concept in French philosophy and French academy in order to show how some concept try to be a bridge, in fact, a relational concept between the world of nature and the world of society, the world of public authorities, and etc., etc. So, some question about the use of this concept, the perception of this concept. Is a paradigm, a new model of conservation, or just a placebo, palum, or oxymoron? It's very, very interesting to think about this question. Ecosystem services, in EU law, we have one definition. As you can see, it's a definition very particular. It's broader than the definition we can have in the Millennium Assessment ecosystem. But we have, in fact, situation very unstable. We have an unstable definition because EU law, it's not only the directive on environmental liability. So we have another rule, of course, and we have another concept in competition of in complementarity as the concept of environmental services used by the FAO. So we have to ask some question about the function of this concept, just a function for explain to the policy maker, to explain to the private sector and to explain to the public that it's important to protect ecosystem services, or it's a normative concept. It's very different, and we can see that it's very, very different if we ask a question to an ecologist or if you ask a question for an economist. We have different answers to this question. Governance, we have a definition proposed by the Commission in 2001. As you can see, it's a very classical definition because this definition insists of different points. The fact that we need a plurality of actors because some problem present some characteristic, for example, characteristic of diffuse phenomena, complex phenomena, collective phenomena, etc., etc. So it is possible for the state, for the public authorities, to try to reach all the objectives due to the characteristic of this problem. But the concept of governance is very, very hybrid concept because very ambivalent. Some lawyers don't want to use this concept because it's not a legal concept. For others, okay, we can combine this concept of governance and the concept of governance. So it's again a concept which creates different debate because in fact it's a debate about the democracy, the deliberative democracy or representative democracy. It's a question also of authorities. Who decide? Who has the authority to decide that ecosystem services need to be protected by economic valuation or not by economic valuation? So it's a question of authority and also a question of legitimacy to decide. So I think it's a question for lawyers also to decide all those questions. So, my 3 points. Who decide? Who decide is the concept of ecosystem services invite us to rethinking of a new legitimacy of authorities, to rethinking and to follow an economic pragmatism. It's an ideal, illusion, or a reality. Can we imagine and rethink the power, in fact, of law, the power of political function? Who decide 2 points? We have to focus on the multiplicity of actors. So it's the question of how to share, how to have differentiated responsibility to protect ecosystem services and biodiversity. So in very classical mention for the EU to insist, to focus on the participation of civil society and private sector. Of course, we have legal rule and we have European strategy to show that it's a necessity to have and to reinforce the participation of civil society. But this multiplicity of actors is not only on the territory of the EU law, of course. So for the EU, it's important to try to promote this participation on the territory of EU law and, of course, in the external relation of EU law. If the EU law wants to influence, to be an international leader in environmental issue, she needs to be exemplary. Yeah. My second point is about the distribution of competency between legal authorities and economic private power. Of course, in EU law, perhaps you know, of course, but in the system, legal system on EU law, in EU law, is very, as you can imagine, governance laboratory. Because all the competencies of EU law is based on different principles, and for the concern of environmental issue, the policy of EU law based on principle of subsidiarity. So immediately we have a multi-governance between the different authorities, public authorities in EU law and in the member state law. The distribution of the competencies based also on an integrated approach and the principle of integrating. So it's a question of coherence. Coherence are many authors, and this morning and this afternoon, many presentators explain that we have a fragmented approach. All is fragmented. So we need to reach coherence, but in EU law we have to consider that it's an ideal, because we have more and many difficulties, not only to have an integrated approach in the environmental policy, but also it's very difficult to integrate the environmental requirement and especially biodiversity requirement. It's completely different if we think about climate change. I remember Ghent, for example, colloquium of Ghent, completely different of biodiversity and climate change. And I want to focus also to the insufficient green diplomacy of EU law. And again, we have an important gap between the discourse, political discourse, okay, and the reality, the legal reality. We don't have in EU law a green diplomacy. We don't have enough financial tool, enough human resource, to be a real leader on the international scene. So, to finish about the first question, who decide? I think we have to rethinking political shows. We have to think about how to conciliate the value plurality, and of course, how to conciliate it and combine legal right and duty and social responsibility. My first point about this rethinking is environmental general interest. Is the responsibility to define environmental general interest? Is it a responsibility which is to be shared between government and society? And for example of ecosystem services is very, very important, because this concept is really between environmental general interest and private interest. The European Commission insists to explain that EU law don't have to impose one model. We need to have a plurality of model of governance. It is important if you think about the international external relation of EU law with a developing country. But we know, again, the gap between the discourse of EU law and the reality, because we know that EU law wants to export its model of governance, its model of biodiversity protection. Another point is interesting too, is to think about the clarification of the role of public authorities. Is public authorities ecosystem services provider? Is a new function to the state to be ecosystem market organizer, only organizer to regulate and to have not to be the head of a system, but just to be a regulator? And in fact, it's a problem also of the financial capacity and technological capacity. The necessity to have a clear distribution of responsibility and power of the actor, of course. In the white paper of the European Commission of European Governance, the Commission lists different principles of governance. Transparency, of course, but who decide the transparency? Accountability, yes, of course, but I will say, is it possible to control this accountability? Legitimacy, again, information participation also. And for our subject of ecosystem services, I don't know if in your country you have such process, because in France we have a process in LAFNOR. LAFNOR is like ISO, but it's national ISO. And LAFNOR has decided last year to work about a norm, a technical norm of ecological engineering. Okay? ISO also, as we have now a norm, technical norm of responsibility, social responsibility. Okay? Is it the role, is it the function of such entity, technical entity, to decide it, not only technical problem, but it's more technical problem. If we take the question of corporate responsibility, it's different. Yeah. So we decide in fine. I don't know if we use this expression, yeah, in English, in fine. Latin expression, so I think it's... So we decide for ecosystem services. Scientific aspect, economics expert, beautiful evaluation, modelization, economic evaluation, okay. We decide, why not, the new intergovernmental platform for biodiversity. So we need to rethinking of political. we need to rethinking of a performative, normative and performative function of a law. How? So, commodification process. Several authors, as Corbera Estelle, she wrote many papers on payment for ecosystem services, and she asked the question, she's not a lawyer, yeah, but she has a question of a commodification. And so for a lawyer, we have to ask the question, what can do law face this process? To construct this process of commodification? You can. It's possible for the lawyer to do that. Or to say, no, it's not possible. We have some limit for the concept, for the process of commodification. One limit, common patrimony, of course, outside the market, if we decide this. So, how I focus my presentation of two points. We try to find a complex combination of regulatory instrument and market-based instrument, and try to combine again efficiency, effectiveness, legal effectiveness, and coherence again. Oh, sorry, French. So, to do such combination, we have to reinforce the implementation of a legal conservation framework. If we don't do that, of course, the process of commodification will go and go and go and go again. So we have to reinforcing the implementation of legal conservation framework and to promote an ecosystem, oh well, I'm so tired, ecosystemic approach, species, habitat and function, of course, and try to think about a legal status of ordinary biodiversity, because ecosystem services is not only in for remarkable, yeah, biodiversity. We need to think about ordinary biodiversity and to think about the green infrastructure, of course. Enhancing the financial subsidies, of course, because it's a major problem for all the conservation framework in EU law, because we don't, EU law, in EU and member states, don't have enough money to protect. So we need to find innovative instruments, to find innovative funds. So the link with the private sectors is a necessity. So I gave some example of payment of ecosystem services, and we have many papers on this during this week, so it's very interesting to listen all those reflections. And we have to think about also about the ecological sustainability and the ecological compensation. Because if we follow the line of the process of commodification, we have to think about if it's possible to substitute an ecosystem services by another ecosystem services. It is possible to organize such compensation. In EU law, the Commission, European Commission, has decided last year, and we don't have now its studies, but it's ongoing, yeah? A study on how to create on the EU law compensation framework as we can have in America or in other countries. Why not? But if the EU decide to do that, I think it's important to have in mind the major difficulties in America or in other countries we have about such system. If we don't want to reproduce, I don't know, no? To do the same. my second point about how to do this is, of course, to reinforce the democratic right and legal procedure and institution. 3 points about this solution. The European Commission focused on the principle of European governance to say we have to be open, we have to ensure participation, etc., etc. Okay. But we have to have in mind that we normally respect the Paris Convention. Normally, we have to respect it. But in EU law, we don't recognize the right to environmental as in several member states. So why not to go in order to recognize such right to environmental? The opportunity to diversify the tool for deliberative procedure. Okay, everybody can know the philosophy of Habermas, this deliberative democracy and procedure. In EU law, thanks to the Treaty of Lisbon, we have a new procedure. It's called the Citizen Initiative, and it's possibility for 1 million European citizens to propose to the European Parliament a proposal. And for example, we have a proposal about water issue. Why not about ecosystem and biodiversity issue? And the EU law have also different campaign and different public consultation of biodiversity. And my last point about this democratization, it's about the construction of the reinforcement of institution, of governance institution. We have in EU law one environmental agency. But this agency, created in 1990, là je suis fatiguée, 1990, oui. Such agencies have really just a role to collect information. So why created a real agency? Just one? Zero? Yeah, okay. So you can read the question. So where? It's a crucial debate. I want to focus on 2 points. The encouragement of local, regional, of course, and international scale. We have to have in mind that ecosystem services, their provision and their distribution is very heterogeneous. So we have to take into account this characteristic. We have to take into account also the complex relationship between function and ecosystem services with ecosystem services. So we have to be aware of the risk of a fragmented approach of ecosystem services. And of course, we have to think about the territory of ecosystem framework, because ecosystem services are not only in protected areas. So how to combine protected areas and the other areas at the different scale? Why you had speak about district ecosystem services district are the same. Okay, why not think about such territory? The past, the present, and the future. Yeah. We have to take into account the past of ecosystem services in order to protect at the present and for the future. So it's important in order to construct a legal framework on ecosystem services to have the free time, the free age, past, present, and future, of course. As a conclusion, I want to insist of the importance for the lawyer to share their vision of ecosystem services, because we have many and many studies on economic, from scientific, but a few legal vision of this ecosystem servicing. And I think it's very, very important to think about such concept, because this concept force us to rethinking of the foundation of environmental law. And I think, despite its risk, I think this concept is very, very interesting to think about such foundation. Okay, thank you. I'm sorry, so my bad English.
We have time for one very quick question, if there is one. Otherwise, we'll we'll move towards our concluding remarks. Is there one quick question? Okay, go ahead.
Earlier you mentioned that the EU do not have the human resources and the capacity and the mandate to be an environmental leader. I'm asking you, if it's not the EU, who is it?
If a member state decide, or if they have the political will, they need to transfer competency for the EU law. But in fact, the member states don't want to do that. And if you see different conventions for climate change, the EU law has an important discourse to, okay, I am the leader because the United States are not there. So the European have the leadership, but it's not a reality. It's not a reality.
But I think if it's not the EU, I think the EU has to take that role.
Yeah. I'm agree with you. We have to do that. But EU law doesn't have enough financial capacity to do and to follow all the negotiation and all the implementation. So it's a challenge for EU law.
Great, thank you very much. And thanks to our panelists today, right now. So we're going to hear briefly from Elizabeth Kirk, who's one of the co-editors of the IUCN Academy's e-journal, and she's going to talk about the call for papers.
Okay, this will be very brief. I hope that you are all familiar with the Academy's e-journal. Just in case anybody is not familiar, I'll just say a few words about it. It is an open access journal, so it's available on the internet for anyone to use. The objectives are, of course, that we provide a forum in which we support the Academy's members in exchanging discussions about latest understandings, latest developments in environmental law. We publish papers, or we aim to publish papers, in 4 languages. We would like to publish papers in all of the UN official languages, but for cost restraints we're stuck with 4 languages at present, and those languages are English, French, Spanish and Mandarin. And at present we're publishing 1 issue a year, and each issue is on a particular theme. Now, to try and support the work of the research committee, we decided this year to tie our theme to the theme of this workshop. So we are soliciting for contributions on the theme of this workshop. Any contributions should be submitted by the 30th of November for this year. There should be a maximum of 8,000 words in length. And all contributions will be subject to blind peer review. So maybe for the sake of the North Americans, I'll explain that process. When we receive papers, we remove any details that would be able to, by which anybody reviewing the paper would be able to identify the author. We then send the paper out to normally 2 academics, occasionally 3 academics who are experts in the area or in as close to the area as possible, and we ask them for a review of the paper. And so they're looking at their academic content as well as perhaps how it's presented, how the arguments are presented. And then, having received the comments of the reviewers, we decide whether the paper is publishable. You know, we're guided very much by what the reviewers say. Sometimes then we have to go back to the authors, as you would have, I think, in the North American system, and ask for some revisions, and we go through a process like that. So our aim then is, having gone through the peer review process, we would aim to choose the best 3 or possibly 4 papers to be published in the next issue of the e-journal. Now, the deadline, as I said, is 30th of November. We would aim to have the next issue of the e-journal published by around the end of March in 2013. Melissa mentioned that there are tentative plans to publish papers from the workshop in a book. If people are interested in publishing, if those plans come to fruition, if people are interested in publishing in both the journal and the book, then we can certainly discuss that, any copyright issues, and make sure any copyright issues are resolved at that stage. I think that's all that I needed to say. Finally, I should say that our call is, of course, open to the presenters at this workshop, anybody else at this workshop who is interested in submitting a paper, and to the wider academic community. So I hope some of you will consider publishing with us, and we look forward to receiving contributions. Any questions? If anybody does have any questions, I'm around for the conference, so please do get in touch. Okay. Thank you.
So I'll just give a few concluding remarks. I have 5 things to say. First thing, thank you to everyone for these presentations, the discussion. I think it was a really interesting conference. And thank you to the speakers for sending your papers before the beginning of the conference. That was really great to get them. The second thing is that this discussion, we're going to continue this discussion in Korea, as it was said earlier, in the World Conservation Congress. So I don't know if some of you are going to be there or not, but we're developing an event on rights-based approaches to conservation, which is, so on behalf of I'm going to talk on behalf of the Environmental Law Center, the IUCN Law Center only, and say that we've been working on rights-based approaches to conservation for several years, and so this event in Korea is going to be built on the work that we've been doing. And this work has been so the Law Center developed a methodology to implement rights-based approaches to conservation, and we're planning this event in Jeju based on this methodology. So it's going to be divided into different steps from the methodology, which is, for example, the first one is to undertake a situation analysis of any conservation activity to see what rights are involved. The second one is to provide information to the people that are in the area that could be affected. The third is to ensure participation, and so on. So we're working with the Academy on the 4th step of this methodology, which is to take reasoned decisions, and using this workshop as a basis for that activity seemed very appropriate. So on ecosystem services and equity, and discussing, as we did today, some specific questions. For example, how should valuation be done of ecosystem services? How to treat services that lack a clear economic value? What strategies exist for participation in payments for ecosystem services schemes? How to ensure that, how do you tackle questions linked to property rights in PES schemes, and so on. And so this event is going to be basically asking these questions to some selected speakers from different backgrounds, for example, people from indigenous communities, people from organizations, people from the private sector, and seeing how we can compare the answers. So if any of you will be there and are interested, you can also come and talk to me or send an email to us. And we're going to be using these discussions also to develop an introduction for this event, and it's been really helpful. The third thing I wanted to say is that we, as Elizabeth said, we wanted to develop a publication, so things are still being discussed right now with the publisher. We can't guarantee anything, but we're going to do our best to have something done. So we'll let you know more about that. And two other announcements that I've been asked to give. To the graduate students, there's an event on Tuesday at 5 p.m. It's a working dinner, and the topic is publishing your research in room 302. So please take that in mind if you're interested, on Tuesday afternoon. And the last thing is that there's a baseball game tomorrow afternoon after the law clinic. And the tickets, you can pick up the tickets at between 11 and 11:30 in right here. And the open lunch will be when you get to the stadium. It's in the bullpen area, if you know what that means, because I don't. If not, Suzanne can help you, I think. But so thank you very much again. And Melissa, you.
Just two other quick points that I forgot to mention. One, if you haven't registered for the colloquium itself, and if they're not still there today, there's registration tomorrow from 4 to 6. It's advised that you try to register early so that there's not a flood of people the early Monday morning. And second, thank you very much for all of the facilities and IT help today. Thanks, IT guy. It was very helpful. That's it. So, and thanks to everybody for coming, and good luck getting some sleep and adjusting to the time and the heat.